Okay, so I'm Kaden. This is Justin. The case that we picked for a presentation is Goldman versus Weinberger.
So as you said, we're going to be talking about the Goldman versus Weinberger case. The case number was 475 US 503. It was decided in 1986, first argued in January 14th, and finally decided in March 25th of 1986.
Starting off talking a little bit about the petitioner, Simcha Goldman was an ordained Orthodox Jewish rabbi who was accepted into the Armed Forces Health Professionals Scholarship Program in 1973. With the help of the scholarship, he completed his degree in clinical psychology from the University of Loyola in 1976. As part of the agreement of the scholarship, he joined the Air Force as a commissioned officer stationed at March Air Force Base in Riverside, California. That's where he practiced for about 5 years while also wearing his yarmulke without any complaints.
So the respondent was Kaspar Weinberger. He was the head executive of the Department of Defense under President Ronald Reagan from 1981 to 1987. While Weinberger is on the name of the case, it was only because he was the Secretary of Defense and was a representative of the entire department, meaning this was not personal between him and Goldman. However, he was still defending the rigorous dress code, Regulation 35-10, that headgear may not be worn except by armed security police in performance of their duties.
Some facts about the case of Goldman versus Weinberger. For about 5 years, Goldman was not prevented from wearing his yarmulke on the base. He avoided controversy by remaining close to his duty station in the health clinic he worked at. And when going outside, he would typically wear his service cap, not to draw attention to himself. Ultimately, his efforts eventually failed in 1981 when a complaint was lodged against Goldman while acting as a witness for another in-court martial. The defendant's attorney, out of spite, complained to Colonel Gregory as a result.
So Colonel Joseph Gregory informs Goldman that he violated Regulation 35-10 by wearing his yarmulke while in uniform. He first told Goldman that he was not allowed to wear the yarmulke outside of the hospital. Later, instead of respecting his religious beliefs, Colonel Gregory doubled down and said he could not wear it inside the hospital either. Goldman's refusal of this order was based upon the belief of Orthodox Jewish men always wearing a yarmulke, as it is felt as a way of honoring God. For not following these orders, Goldman was threatened with a possible court-martial. Later, Colonel Gregory withdrew his recommendation of Goldman's application to extend the terms of his active service. To me, this is starting to sound a little more personal between Goldman and Colonel Gregory.
Okay, so the case finally starts to begin here. It first begins with Goldman's attorney lodging a complaint to the Air Force General Counsel. The basis of their action was that Regulation 35-10 infringed upon Goldman's First Amendment freedom to exercise his religious beliefs. The General Counsel then rejected his First Amendment argument. Goldman then argued that Regulation 35-10 applied to him as it prohibited religiously motivated conduct and should therefore have been analyzed under the standard enunciated in Sherbert v. Werner in 1963. While this issue was ongoing, Goldman made a reasonable request to be allowed to wear a civilian uniform until the issue was settled. This was a reasonable request because many psychologists that worked at the hospital were actually civilians themselves.
So the case first went to the district court where Goldman won his case. But unfortunately, the armed forces appealed to the district appeals court where they appealed the district court decision. Since Goldman felt that this was a First Amendment case, his attorney petitioned to the Supreme Court to grant a writ of certiorari, which was granted. A writ of certiorari is when a Supreme Court orders the lower court to send the case for review.
Okay, so the Supreme Court decision eventually well, actually, unfortunately, Goldman lost his case on the Supreme Court level with a very close sim 5-4 decision. The Supreme Court ruled that the US armed forces did not violate military personnel's First Amendment right by prohibiting soldiers from wearing religious apparel.
So writing for the majority was Justice William H. Rehnquist. He held that when evaluating whether military needs justify a particular restriction on religiously motivated conduct, courts' judgment of military authorities concerning the relative importance of a particular military interest, the military held that their policy was necessary to foster instinctive obedience, unity, commitment, and esprit de corps.
So, writing for the minority was Justice Brennan, as he criticized the majority's credulous deference to unsupported assertions of military necessity. He actually mocked the notion that allowing a yarmulke would lead other soldiers to begin to question the principle of unswerving obedience. Thus, shall our fighting forces slip down the treacherous slope toward unkempt appearance, anarchy, and ultimately defeat at the hands of our enemies. End of quote. He and the other justices argued that the Air Force's justification did not satisfy the compelling state interest test from Sherbert v. Werner in 1963.
So it is in our opinion that this one case is where the Supreme Court made an erroneous decision. We believe that this regulation was too harsh on Goldman, as his yarmulke did not hinder his service and neither bothered anyone. It was only out of spite where the issue arrived. Further, we believe that when a military service burdens the free exercise rights of its members in the name of necessity, it must provide as an initial matter and at minimum a credible explanation of how the contested practice is likely to interfere with the preferred military interest. Unabashed ipsa dixit cannot outweigh constitutional right. At no point did the Air Force prove that wearing a yarmulke would disrupt the service, as Justice Brennan indicated in his rebuttal. As stated in the Sherbert v. Werner, that to limit free exercise rights, you must first prove that there is a compelling state interest, meaning that a court asks only whether governmental regulation might serve some legitimate governmental interest. At no point did the Air Force prove that there was a legitimate reason to limit Goldman's religious right to wear his yarmulke. If the Air Force's concern was the ability of their troops from performing properly because of religious apparel, then they could have written specific rules about what would and would not be allowed.
Moving on to military necessity. Since the majority thought that they should give, the majority thought that they should give the military deference, and Chief Justice Brennan also cited the Korematsu v. United States, where the government allowed the internment of United States citizens of Japanese ancestry in World War II, many of whom were actually American citizens. This was unfortunately a very shameful part of some of our American history.
Obviously, the US Congress agreed with our opinion, as many congressmen considered the decision dubiously, as they were quick to pass new legislation which essentially overruled the decision in this case. In 1988, Congress passed the National Defense Authorization Act, which allowed people in the military to wear religious apparel while wearing the uniform of members' armed forces. This was passed into law with Ronald Reagan's signature.
So, a little concluding thoughts from each of us. I think my personal thoughts about the case was that the Supreme Court actually decided wrong about all this. I believe that Goldman should have had the right to wear his yarmulke, and that the Supreme Court and everyone involved in the case should have been aware of this situation, aware that Goldman has a First Amendment freedom to wear his yarmulke and show his religious beliefs, his values. And so that's my personal opinion, that he should have been allowed to wear it. He was trying to keep it on the down low, I think, where he wasn't trying to get attention from anyone, but he was solely trying to just keep up with his traditional beliefs, being a Jew.
So I also disagree with what the Supreme Court decided. I also believe that He should have been left alone, and he should have been able to wear his yarmulke because it's, as he said, it's his First Amendment right. He has a right to do it. Should have been just left alone. However, I do see where the military was coming from, where they quoted the indistinctive obedience, unity, and commitment. The military was trying to say that they wanted uniformity of all their troops and all their soldiers. At any notice when we had to go to war, there wasn't going to be any backlash, there wasn't going to be any back talk about what they could wear, what they wanted uniformity, they wanted unity, they wanted just obedience, and without making any judgment, they wanted them to agree with what the army was saying.
Yeah, so that's all in all. I think we both agree that the court made a poor decision, that they should have thought a little more into First Amendment rights. But that's a little bit about our concluding thoughts, and that's the end of our presentation. So thank you very much for your time.